is Jan Stiefel, and I'm an attorney in the Elder Law Unit at Community Legal Aid. This is an introduction to advanced directives. Every adult of sound age, 18 and over, can take important steps through the use of advanced directives to ensure that in the event they can no longer make or communicate informed decisions about their needs or preferences, their wishes will be respected and carried out by others. These steps can be taken by any person who has not had a guardian or conservator appointed on their behalf by a court of law and who can, at the time of signing, understand what he or she is doing. Taking these steps in a timely fashion may also help avoid the need for costly conservatorship or guardianship court proceedings in the future. I will give a brief description of various types of advanced directives, such as living wills, healthcare proxies, powers of attorney, including durable powers of attorney, and the most. The term advanced directive is a general one used to refer to a variety of written documents which allow people to express their wishes as to how they want health, financial, and other personal decisions about themselves to be made. The documents may also designate a specific person to make those decisions for them. It is important to remember that every state has its own set of laws governing these types of documents. These laws give the documents their legal significance. Not all documents are valid in every state, and not every state will honor another state's documents. Seniors should be aware that written materials, which are directed and distributed to a national audience, may contain information about advanced directives, which may not apply to Massachusetts residents. Starting with a healthcare proxy, that is a document authorized by Massachusetts law, which permits you, as the principal, to appoint a person that you know and trust to act as your healthcare agent. This person will make decisions for you if, for any reason and at any time, you become unable to make or communicate decisions yourself. The authority of the agent to make decisions for you under the healthcare proxy is invoked only after your doctor has determined that you lack the ability to make or communicate your own healthcare decisions. The agent would then have the ability to consult with your healthcare providers, consider what they know of your preferences, and make healthcare decisions on your behalf. Massachusetts law allows language to be added to the healthcare proxy to provide a description of preferences. Prior to completing this powerful document, it is essential that you consult with those whose opinions you value and that you have a serious and honest discussion with the person whom you intend to designate, so that they are clear as to your preferences and your reasoning. In my experience, this is preferable to adding language to the healthcare proxy document regarding your preferences, which may be confusing or out of date when the healthcare proxy is invoked. The living will and the most, discussed later, provide a means for such directions. If your condition changes for the better and you regain capacity, and your physician confirms this in your medical record, the healthcare proxy is deactivated and you can make your own healthcare decisions again. If the healthcare proxy has been invoked, but you disagree with your agent's decisions and communicate this in any way, your healthcare provider is supposed to go to court to determine whether you, your agent, or someone else approved by the court will make healthcare decisions going forward. There are some important things to keep in mind. First, you do not have to sign a healthcare proxy document, although healthcare providers are required to tell you about them. A healthcare proxy is not a don't treat document. It is a way to ensure your doctors know that you do or do not want extraordinary efforts to prolong your life made by having your agent tell them. You do not need a lawyer to sign a healthcare proxy document. Let me say that again. You do not need a lawyer to sign a healthcare proxy document. There are rules, however, on who can serve as a witness and what the document must say. Your medical provider is the best resource. Your medical provider will have blank forms and be able to assist you in completing and signing the form with the proper witnesses. Finally, it's important to remember that this document will be of little help if the people treating you do not know that you have one or have a copy. Be sure all your medical providers have copies and that the agent has copies to bring to hospitals and other facilities in case of emergency. You can do a new document as long as you understand what you're signing at that time, and it will replace the former document. The document provides the ability to assign a substitute agent if the original named person becomes unavailable. Moving on to a living will. A living will typically contains instructions describing which medical procedures you would want performed or not if you become seriously ill and unable to tell your doctor what you do and don't want. However, a living will is an example of a document that is not recognized by Massachusetts law. Some Massachusetts seniors choose to execute a living will anyway because it provides a written statement of their preferences, or because they do not have someone they trust to act as their healthcare proxy. MOLST stands for Massachusetts Medical Orders for Life-Sustaining Treatment. It is a form intended for use only by individuals with serious advanced illness. It is a medical document, not a legal document. It is signed by the individual and their physician, and it is intended as a communication with medical professionals. It does not substitute for the healthcare proxy document. Another type of advance directive authorized by Massachusetts law is called a power of attorney document. It is used to ensure that someone you have designated can handle your financial or personal affairs for you during your lifetime, especially if you become incapacitated. As with the healthcare proxy document, at the time you execute a power of attorney document, you must be able to understand what you are doing. The document can be drafted as narrowly or as broadly as necessary for your circumstances. The power of attorney document does not need to be filed with any state agency. However, I strongly recommend that a power of attorney document be executed with the assistance of an attorney to ensure that you, the principal, fully understand the scope of authority you are giving to your agent. A traditional power of attorney document gives another person, your agent, the power to do specific acts, such as sell or transfer real estate, withdraw money from the bank, or apply for government benefits for you, the principal. It automatically ends when you become incapacitated. A durable power of attorney gives similar powers to the person you designate, but it doesn't end when you become incapacitated because it contains specific language that indicate the power of attorney is not affected by the subsequent disability or incapacity of the principal. The durable power of attorney is the advance directive to consider to make sure you get to choose the person to handle your affairs when you can no longer do so. Different from a healthcare proxy, a durable power of attorney document goes into effect immediately upon being signed, unless it specifies some other date or has language such as that it goes into effect upon determination of my incapacity. However, by giving someone else the power to make decisions or take actions on your behalf now, you are not giving up your right to continue to make your own decisions as long as you are capable. Having a trusted agent to handle some of your affairs before you are incapacitated can be useful for situations where an individual is overwhelmed and seeking help with handling some of their affairs, and they still retain capacity to function independently. Finally, the person you name as your agent is required to act in your best interest and is accountable for their handling of your funds and your property. A durable power of attorney can be revoked at any time by putting in writing that it is revoked and providing notice of its revocation to at least the agent and preferably to the bank and other entities with whom the agent may interact. The durable power of attorney expires when you die and does not replace a will. By using the tools available under Massachusetts law, seniors can have a better control over important events in their future by preparing now while they have capacity to do so. If they take their time now to learn about using these documents, to discuss their options with trusted family, friends, and professionals, and to choose their agents wisely, they will be going a long way toward avoiding possible future problems, including court actions for conservatorship or guardianship. Thank you.